Judgment in the appeal RM against the Scottish Ministers.
The judgment in this case will be given by Lord Reid.
In 2003, the Scottish Parliament passed the Mental Health Care and Treatment Scotland Act, which reformed the law relating to mental health. It was based on a review carried out by the Millen Committee. One of the committee's recommendations was that patients should have a right of appeal to be transferred from the state hospital or a medium secure facility to conditions of lower security. As introduced, the bill which became the 2003 Act did not contain any provision to implement that recommendation, but in response to promptings within the Scottish Parliament, provisions giving effect to the recommendation were introduced and enacted. The provisions dealt separately with patients in state hospitals and patients in other hospitals. Patients in state hospitals could apply to the Mental Health Tribunal for Scotland, but the tribunal could not deal with applications without allowing the relevant health board to make representations and produce evidence. The expression relevant health board was to be defined by regulations made by the Scottish ministers. In relation to patients in other hospitals, qualifying patients in qualifying hospitals were permitted to apply to the tribunal. The expressions qualifying patient and qualifying hospital were again to be defined by regulations made by the ministers. The Parliament also enacted that these provisions were to come into force on the 1st of May 2006, or such earlier day as the ministers might appoint. The deadline of 1st May 2006 was the result of an amendment which the ministers accepted, saying that it would provide a guarantee that the new rights would be brought into force no later than May 2006. In the event, the ministers made regulations defining what was meant by a relevant health board, and the provisions concerned with state hospitals came into operation on the 1st of May 2006. But no regulations have ever been made defining what is meant by a qualifying patient or a qualifying hospital, with the consequence that the provisions concerned with patients in other hospitals cannot be operated and have no practical effect. This case has been brought by a patient who wishes to apply to the tribunal but cannot do so in the absence of regulations specifying which patients are qualifying patients and which hospitals are qualifying hospitals. He applied for judicial review of a minister's failure to make the necessary regulations, but his application was refused by the Court of Session. It held that there was a fundamental difference between the provisions concerned with state hospitals, which in their view conferred a right on patients that did not require the making of any regulations in order to be effective, and the provisions concerned with patients in other hospitals. It inferred that the Parliament had intended ministers to have a discretion as to whether the provisions concerned with those patients should ever be brought into effect. It accepted that there would be a duty to make regulations if that was necessary in order for a right to be effective, but considered that that principle did not apply in this case because no rights had been conferred on patients in hospitals other than state hospitals as a result of the failure to make the necessary regulations. This appeal is brought against that decision. The Supreme Court unanimously allows the appeal. It considers that no fundamental distinction can be drawn between the provisions concerned with patients in state hospitals and patients in other hospitals. Under both sets of provisions, regulations had to be made before the provisions could be put into operation. It also considers that one cannot rely upon the fact that no rights have been conferred on patients in order to infer that ministers are under no duty to make the necessary regulations, since it is precisely because no regulations have been made that no rights have been conferred. The reasoning is therefore circular. The Supreme Court also considers that it is not only where the exercise of a discretion is necessary to make rights effective that there can be a duty to exercise the discretion. It has long been settled law that a failure to exercise a discretionary power conferred by statute will be unlawful if it is contrary to Parliament's intention. The real question, therefore, is whether the Scottish Parliament intended that the provisions in question might never come into effective operation, or intended that they should come into operation no later than the 1st of May 2006. The Supreme Court notes that the Parliament set a deadline for these provisions to come into force. In doing so, it must have envisaged that the provisions would be brought into effective operation by that date. Parliament is not given to passing futile legislation. It legislates in order to bring about a practical result. Furthermore, it would make no sense for the Scottish Parliament to set a deadline for futile legislation to come into force. It follows that since the Scottish Parliament must be taken to have intended that the provisions would come into effective operation by the 1st of May 2006, the ministers were therefore under a duty to make the necessary regulations by that date. The Court therefore grants a declaration that the failure by the Scottish ministers to draft and lay regulations before the Scottish Parliament prior to the 1st of May 2006 and their continued failure to do so since that date was and is unlawful.
The Court will now adjourn.